A case going through the Idaho Supreme Court could severely impact Idaho ski resorts. It starts with the 2019 lawsuit after a skier died on Bald Mountain in Sun Valley. Bringing in Abby Welt now. You've gone through this case. What was in it?
Hunter, ski resorts across Idaho are worried that the Supreme Court decision could remove their current protections against Idaho's Ski Liability Act and ultimately put smaller resorts out of business.
Skiing is an inherently risky sport.
In November of 2019, Stuart Milas was skiing at Sun Valley Resort when he collided with a snowmaking machine equipped with yellow padding and died.
It's a tragic case.
His widow, Laura, filed a wrongful death lawsuit against Sun Valley Company, and a lower court ruled Sun Valley fulfilled its duty to mark snowmaking equipment.
The trial court granted summary judgment and said that the case could not move forward because skiers in Idaho take responsibility.
The Idaho Supreme Court reversed the lower court's decision in December of 2023, saying the resort should have had more warnings about the snowmaking equipment.
It was confusing. If a big yellow pad is not a warning implement, then what is?
Now, Idaho's Supreme Court will hear arguments this Friday, but outdoor recreation and ski liability attorney Jordan Lipp, who isn't representing any side of this case, says the outcome could severely affect ski resorts in Idaho.
The bigger impact is on the smaller ski areas for something like this.
Ski resorts are currently protected by Idaho's 1979 Ski Liability Act, which states resorts need to warn skiers about dangers, but it's also up to the skier to protect themselves.
The responsibilities to ski in control, to act properly, to know what you're doing.
If Idaho's Supreme Court rules against Sun Valley Company, Lipp says those protections for resorts in Idaho's ski statute could go away.
That's part of the reason why Idaho passed the ski statute in the late 70s and why most states have ski statutes, is because of those litigation risks for an inherently dangerous activity.
And liability insurance costs could go up.
Have it keep working. You can't have too much of a litigation risk for these ski areas.
And ultimately, Lipp says close down resorts if skiers start filing lawsuits over a sport he says is a personal risk.
Lawsuits are expensive, time-consuming, stressful. For a small ski area, a single lawsuit loss could put them out of business.
And the Idaho Ski Areas Association tells me they're deeply concerned about this case and think it could have a detrimental impact on the future of Idaho's ski areas. They go on to say the outcome could not only hurt rural economies, but also jeopardize the outdoor lifestyle that's unique to Idaho's identity. And Hunter, again, the Idaho Supreme Court will hear arguments this Friday.
Yeah, we're going to see what happens there. Thank you, Abby.